Let's talk about judgment as a matter of law. So another way that judges take the decision-making power out of the hands of the jury. We've actually already seen a version of judgment of a matter of law as a matter of law just a few days ago when we talked about summary judgment. And the standards you're going to see here are very similar. It's mostly the timing and the nomenclature that gets tricky. So let's just walk through it. So judgment as a matter of law under Rule 50A is otherwise known as a directed verdict. So the standards here are, I'm just quoting from the rule, that if the party has been fully briefed on an issue during a jury trial and the court finds that a reasonable jury would not have a legally sufficient evidentiary basis to find for that party on some issue, then they should grant judgment as a matter of law on that issue. Again, I hope that sounds familiar. That's basically the language we use to describe summary judgment. And in fact, Rule 56 describes summary judgment as a judgment as a matter of law. So these are really connected. The reason that this is called a directed verdict is because in the old days, when this was first introduced, a judge would actually direct the jury to return the verdict that the judge had decided it should return. So we're directing the jury to make a verdict. The standards for a motion for judgment as a matter of law under 50A, again, just like summary judgment, the judge is not supposed to weigh the evidence themselves or make credibility decisions. They're supposed to determine whether a jury could reasonably rule for the non-moving party given the evidence presented. So will the jury have to choose between competing stories, or is there only one story that they could reasonably choose? Okay, let's distinguish this from its close cousin, a renewed judgment as a matter of law under Rule 50B. So these are intimately connected. This is otherwise known as a judgment notwithstanding the verdict, or JNOV. And the standards are the same as Rule 50A, but the timing is different. So a directed verdict comes at the close of an opposing party's evidence or at the close of all evidence. You renew that motion after the jury verdict. That's 50B, and that's why it's called a judgment notwithstanding the verdict. So the jury has returned a verdict, but we're asking the judge to ignore that and grant us another verdict, notwithstanding that one. So here's how it looks in terms of the timeline of these things. So we've got our initial moves and the meat, right? Complaint, pre-answer motions, answer, discovery. All right, summary judgment, we're moving on to trial. What happens during trial? Well, the plaintiff puts on their evidence first. Once plaintiff's evidence is put on and defendant has cross-examined plaintiff's witnesses, that is the first opportunity for defendant to make a motion for a directed verdict under 50A because the opposing party's evidence has already been put on. Then defendant puts on their evidence, plaintiff cross-examines, and then plaintiff has the opportunity to make their 50A motion for a directed verdict. And actually, I should have defendant in here too, because defendant could make it here as well, since all the evidence has put on. Say that's denied or both of those are denied and the case goes to the jury returns a verdict. Now is the point at which both plaintiff and defendant can make their 50B motion, renewing that 50A motion for a judgment a judgment notwithstanding the verdict, JNOV, or alternatively, or together, a motion for a new trial. So just again, a nomenclature issue, both 50A and 50B are called judgment as a matter of law. So you just want to specify which one you're talking about and figure out what other people are talking about, because you'll hear it both ways. So here's one question. Why would you want to make both a 50A and a 50B motion? So make the first motion for a directed verdict and then renew that motion, asking the court to do the same thing that it just refused to do. So one reason to make a 50A motion is that if you want to make a 50B motion, you have to have already made a 50A motion. So if you think you're going to be asking for a judgment notwithstanding the verdict, you better have made a directed verdict motion. In terms of court psychology and the practical way that cases go, sometimes hearing half the evidence gives the court some reason to think about what the outcome should be, but sometimes it's really seeing the jury verdict that spurs the court to action. So realistically, there are definitely cases where the court allows the jury to return a verdict, but then overturns it anyway, even having been warned that a party thinks that there's not sufficient evidence. But the really crucial reason to make both of these motions is to preserve the issue for appeal. So we don't talk about appeals very much in this class. We just do that little bit that we did at the very beginning. But you should have in the back of your mind that in order to appeal something from a trial court litigation, you need to have raised that issue in the court below. Otherwise, you're considered to have waived it. And in the case of an argument that a reasonable jury could simply not have reached the verdict that it reached, you need to have made that argument below. You do that with a 50A motion for a directed verdict, saying a reasonable jury cannot rule for my opponent on this evidence. But as of 2006, you also need to make a 50B motion in order to preserve that argument for appeal. So that's a case called Unitherm at the Supreme Court. And it basically says, in order to challenge the sufficiency of the evidence on appeal, you must make both motions. Otherwise, you waive the argument that a reasonable jury could not have ruled for, that the reasonable jury could not have ruled for your opponent. Okay, one other motion that you can make at the very end of trial is a motion for a new trial under Rule 59. The rule is rather enigmatic and says that a court may grant a new trial for any reason for which a new trial has heretofore been granted in an action at law, so common law, right, in federal court. But basically, what that means in practice is that the court should grant a new trial if there's some procedural defect, so maybe the judge has admitted some evidence and then realizes later on that they really should not have admitted it, or if the verdict, the key quote is, goes against the great weight of the evidence. So this is a situation where the judge feels that the jury has made a mistake. It's not quite so egregious or obvious as to warrant a judgment as a matter of law, so to warrant the judges taking the decision-making power out of the jury's hands and using it themselves. But it is unreasonable under the circumstances, and therefore they should try it again. People will often make the judgment notwithstanding the verdict motion, the 50B motion, along with the new trial Rule 59 motion. And the rules actually explicitly say that you can do that because the judge can deny the 50B motion and yet order a new trial nonetheless. So all of these things come into play in the case that we read on judgment as a matter of law, Vajdani. It's a pretty complex case. There's a lot going on there. So as you read it, you might just want to keep note of which claim, which trial, and which result the court is talking about, because there are a lot of moving pieces, but I think it really nicely combines all of these motions and ideas and shows you how they can play out. And I think it also kind of helps us answer a kind of underlying skepticism that a lot of us have about these motions, which is why do we give the judge so many opportunities to move things around in so many ways? You know, if you've already made a summary judgment motion, why on earth do you even need a judgment as a matter of law motion? And I think it gives you some sense of the way that things can interact in complicated ways that make the evidence's implications not totally obvious until it's all on the table already.